Good afternoon and welcome to the June 14th, 2017 Legal and Finance meeting. And we'll start out with roll call and determination of quorum. Thank you. And now we're on to the adoption of the agenda.
So moved.
Second.
We have a motion to approve and a second. All in favor?
Aye.
All opposed? Motion passes. Now we're on to general public comment for the consent items, items 1 through 9. We have no speaker forms on 1 through 9, so I will close that. We will move on to the consent items 1 through 9. Anyone want to pull anything 1 through 9 from the dais? Alderwoman Scott.
Thank you, Mr. Chair. I'd like to pull item 5, 7, and 8.
Anyone else? If not, I'm looking for a motion to approve everything except for 5, 7, and 8.
So moved.
Second.
We have a motion to approve everything except for 5, 7, and 8. All in favor?
Aye.
All opposed? Motion passes. Item 5, approve resolution number 2017-044A, a resolution removing the Rapid City Special Assessment on Track AR2 of Ridge Park Estates. Alderwoman Scott, you have the floor.
Thank you. May I ask Tracy a couple questions, please?
You may.
Thank you. So, Tracy, in looking at this one, it looks like the city is going to acquire this property, but there was some special assessments and quite a bit of interest and penalties built up. The recommendation is that we go ahead and just wipe the slate clean, but the note on here says it will decrease the SAB 28 fund. Can you give us a little bit more clarification on why we would want to do that?
So what it is decreasing in the SAB 28 fund is just the amount that we would typically receive. So we would be, we are anticipating a certain dollar amount based on those special assessments that we have approved. So that amount is what's decreasing that would go into the SAB 28 fund.
And I couldn't tell in here what is the exact amount that it's going to be decreased by. I may have been starstruck by the amount of interest and penalties.
Sorry, it's taking a little bit to load up here. Looks like around $38,000 was the original assessment.
And none of that has been paid off to date?
I am not aware that any has been.
So without any of this money being collected at all, is it that this was just the owners at the time totally just walked away from it, so there's no way to collect any money off of this whatsoever?
Yes.
Mr. Chair, may I follow up a question with our city attorney?
Absolutely.
Thank you. Joel, so with something like this, there's no way the city itself can go after the owners at the time to collect even just the original amount, let alone the interest and the penalties. I mean, if they walk away from it and they don't pay anything on it and it goes back to the county, it's just null and void.
I don't know. What's the size of the assessment?
The original assessment was $38,000. What I read on here as far as the resolution, it's like $151,402.51.
You know, I guess I'm not prepared at this point to say whether there's any way to go after them. I would say normally on an assessment, the reason that we are allowed to place it on the property and collect it that way is usually that's the only way it's ever going to get collected, because even if we can go out and get a judgment against whoever the assessment was against, the likelihood of them being able to pay it is slim to none. So you essentially have a piece of paper that's worthless. And the question is, how much time and effort does it take to get that piece of paper that ultimately isn't worth anything? We could try to look into it, but again, tracking, depending on how old it is, if people have moved out of state, trying to track it down would be very difficult. And then trying to file suit and where to litigate and get them into court would be difficult. I'm not saying any of it's impossible. And then the other question before you would even want to probably consider that would be, if you find them, trying to make a determination of whether they have any assets or income by which you could reasonably hope to get paid from it. So in answer to your question, I can't say that there aren't other ways to go after it, but there would be a lot of questions to answer before we really pursued any of those.
All right, thank you. Mr. Chair, may I follow up? Tracy, please, thank you. So, Tracy, and sorry I misspoke, the county didn't recover this property. I guess the city already owns it?
Yes, the city did acquire it from the county.
So how did the city acquire it? I mean, was it just given to them? The people walked away? I would have thought that normally it would have went back to the county if it.
I don't know all those details at this time. I can certainly do some research and have it for you for Monday.
Well,
Actually, I think Kinsley from my office might have some additional information on that.
Oh, I would appreciate that.
Yeah, Kinsley Grote from the City Attorney's Office. So I looked at a few of the documents, and okay, so part of the reason it was originally put on this piece of property, so there was a special assessment that was put on a piece of property, and it was taken off that piece of property so that it could be platted, and so then it was put on this other piece of property that you are dealing with here now. So that part of the problem with going after the original owners was, I think there was some sort of an agreement with these owners to transfer a special assessment from one piece of property so that they could plat it and put it on this other piece of property. So it becomes more complicated when you're talking about all of the judgment and going after someone for an amount of money. And then yeah, basically I think the person that owned this piece of property, it was, I think it's kind of a hillside, and it's not assessed at much, but I think the county got it through a tax deed and decided to transfer it to the city. I think that's how it ended up falling in the county's hands, was through non-payment of taxes, and so the county took it.
So it did go through the county first.
Yeah.
So did the city approach the county wanting this piece of property?
That history I'm not sure of.
Okay.
But I'd guess that the county probably wanted to not have the piece of property. So
That would be my guess as well.
yeah.
So, okay, I guess my biggest concern is that if there's no way to collect the money, that's, first of all, I wanted to find out what the likelihood was of collecting any of the money. My second concern is the SAB 28 fund. If we don't put this money back, from my understanding, this is a fund that we tried to put the money back in so that we could do other special assessments, correct?
Yes, that's correct.
We don't have another funding source that could actually make the SAB 28 fund whole. We're just going to decrease it and just wipe it clean. We don't have.
So basically, original assessment was done in 1995. So we've been holding that original amount of $38,000 as outstanding to come in. Really, it probably should have been written off by this point in time as uncollectible, but we're not at that point now. We're here at this situation. It's just what we were expecting to receive in the SAB 28 fund is not now going to be less. So yes, there won't be certain projects or assessments that could be done because that money isn't there. We, I guess, probably could try and see where the original assessment came from. The purpose of that, to know where another funding source might be.
Well, and thank you, Tracy, but if it was up to me, I would like to know that so that we would know whether we actually do want to write it off of the SAB 28 or if we wanted to replenish it from the original source, but I'll yield the floor.
Thank you, Alderwoman Scott. Alderman Lorente, you have the floor.
Thank you, Chair. And Tracy, if I could add to that, if it's either the attorney's office or your office, if we can have that information that Alderwoman Scott's looking for, that would be great to have that Monday night. I think the council would find value in that. My question, if I may, Chair, with the city attorney's office, if I may. Joel, is there, just from the conversation that you had with Alderwoman Scott, my question is there a loophole here, or is this just county concern, where the representative from your office talked about how they moved the assessment from one piece of property to the other? Was that a way to allow them to plat this other particular property because there was no longer this overdue assessment on it? And is that something maybe we need to look at from a legal perspective? I'm thinking, is this a loophole we've left open in the law that allows them to move this assessment from one property to another, allowing them to do some work on a property that they want to do?
I would assume there had to be an agreement, but without knowing the specifics,
Okay.
I can't really answer that. But I guess prior to Monday night, we'll try to figure out how that assessment got moved and have an answer.
All right, that would be great. I appreciate it. I yield. Thank you.
Thank you. Alderwoman Scott, you have the floor again.
Thank you. I'd like to make a motion to send this item to council without recommendation, awaiting the further information.
Thank you. We have a motion to send this to council without recommendation and a second. All in favor? Aye. All opposed? Motion passes. Item 7, approve resolution number 2017-045 to create position of fire mobile medic. Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I see Mr. Jeff Barberis here. I'd like to start with a question to him, please. Thank you. So, Jeff, prior to seeing you show up for this meeting, I was going to direct this to the fire department itself, but I know a lot of times these positions always go through your department. So if you could, is the creation of this specific position part of the preparation work for trying to reorganize the fire department between the ambulance service and the firefighters?
I don't believe so. This is just a situation where they're trying to create an individual that could respond to situations that maybe don't need a full ambulance, to try to save money.
So if this position is created, roughly, are we going to transfer employees that are already employed to this position, or is this going out to increase the total employees in the fire department?
I don't believe that they're adding an additional FTE, but the chief could talk to that.
Thank you. So, Chief, if you would please weigh in on this. Is this position being created to advertise to bring in additional employees, full-time employees, or is this going to be used to transfer full-time employees, FTEs, from their current position into this one?
So a little bit about this position. Several years ago, we received a Vukarovich grant to create the mobile medic program. We had a lead mobile medic already in place, and we began the services of that. After several months of that, the South Dakota Board of Osteopaths found that they thought their interpretation was we were working outside of our scope of practice. And so it took a couple years to get with the Board of Osteopaths and work through that process for them to sign on to the mobile medic program. And so the grant was always to fund two positions, the lead mobile medic and then this position. And so now that we're back up and running with the mobile medic program, this is that second position that is grant funded for 2 years. And the short answer to your question is this is already allocated in our FTE level.
So you're saying that this is that the grant was for like 2 positions. This is a second position, but how many FTE? Is it just one FTE to fill this one position?
That is correct.
Okay. And you did say that there's a grant for funding the payroll of this one employee for 2 years, and then it would be picked up?
Yeah, it's actually for both positions for 2 years. That is correct.
So if it's for both positions, so you haven't filled the other one? You were waiting for both of these to be filled?
Correct. We were moving forward when we created the lead mobile medic position and we started the program. We were moving forward with this position, and then when the Board of Osteopaths halted our program for that time period, we halted this as well, not knowing if it was going to come back or not. And this mobile medic program is all in an effort to someday have a full community paramedic program. If you look at other states around us and in the nation, they have a full community paramedic program, which is even expanded more than this one. Like Jeff said, this is a program where we respond one person in a SUV out to certain types of calls that don't necessarily need a full ambulance response. And we try to increase our unit availability on our ambulances that way.
Okay, thank you. I'll yield.
Thank you. Alderwoman Moderick, you have the floor.
I make a motion to approve the resolution number 2017-045 to create the position of fire mobile medic.
Thank you very much. We have a motion on the floor to approve, and a second. All in favor? Aye. All opposed? Motion passes. Item 9, approve resolution number 2017-039, a resolution dissolving tax increment district number 71 for property generally described as being located east of... When I had pulled them earlier, can you read that back? Was it 5, 7, and 9? And 8. Okay, I'm sorry, I thought it was 9. Not a problem. Item number 8. Approve request for transfer of 248 Curtis Street from Pennington County to the City of Rapid City and authorize the mayor to accept and record deed when transferred. Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I'm pulling this item up. So I have a note here, and I'm just trying to look it up. Sorry, I'm a little disorganized on this one. I have a note, and my question on this one was the waiting periods. Yes. Oh, I thought I was on 8. Oh, so I pulled up the wrong, thank you. That is helpful. Thank you, Alderman Laurenti, for getting me on the right item. Sorry, I heard 9 and I must have pulled it up. Okay, so the Pennington County is going to take this tax deed, and then the property contains a house that needs demolition. And the city was going to take ownership of it so the city can use the developmental block grant funds to demolish this. It'll be no cost to the city. So my question is, and I'm not really sure who can answer. Oh,
Kinsley Grote from the City Attorney's
I have
Office.
a representative from the City Attorney's Office, so in looking at this, what's the waiting period from the time the city takes it to the time it goes through? And is the grant funds from the community block grant, community grant, are those the 2016 funds that are being used to demolish his house?
It could be the 2016 funds. So Barb Garcia has to do an environmental impact study, and usually that takes about 45 days from when they start the paperwork to when it's completed. So that would be, it would be a question of whether that's in process already or not. So once the city gets it, then we just have to make sure it goes through that 45-day process, which could be quicker than 45 days till the time it can actually be demolished.
Okay, so and I saw that the community, I can never get the title of that, the CDBG funds, for short. That one just never trickles off my tongue. Since these funds are going to be used, is this part of, and are you aware of this? Maybe Barb would be a better person to ask, but is this part of that, like that lot that could be used for another city partnership with affordable housing?
Yes.
Is that the intention of this,
Yes.
as far as you know? All right. Thank you. If I come up with any other questions, I'll review it Monday night. Thanks.
Thank you. Do we have a motion on the floor?
So moved.
I have a motion to approve. We need a second.
Second.
Have a motion and a second to approve. All in favor?
Aye.
All opposed? Motion passes. We're on to the non-consent items now, and I will open up public comment, and we will start with Mr. Andy Ainsley on item number 12.
Good afternoon. I'm Andy Ainsley, President of Scenic Rapid City, and I'm here to encourage you to oppose the proposed settlement between the City of Rapid City and Epic Outdoor Advertising. I've been very glad to call Rapid City my home for the last 22 years. I run a small business. I've been very active in the business community and other civic organizations. I absolutely love this place and want nothing but the best for our beautiful area that I call home. Being president of Scenic Rapid City, one of our purposes in our bylaws is to promote and carry out programs and initiatives that protect natural beauty in the environment, preserve and enhance landscapes and streetscapes, protect historical and cultural resources, promote enhancement of scenic approaches, improve community appearance, and foster establishment and the preservation of scenic road systems. The proposed settlement will not be good for our fine city and its beautiful surroundings for principally 3 reasons, in my opinion. First, it goes against the spirit of our existing Rapid City Sign Code and Ordinance. The proposed settlement goes against those citizens' initiatives that were passed in 2011 by over 2/3 of those who voted, and it's inconsistent with our city's comprehensive plan. I'd just like to read here briefly. I was also on the Citizen Sign Committee. Doug Rumka's in the room, was one at the time, and the preamble to the sign code back in 2007 said, whereas the City of Rapid City finds that the scenic beauty of the city is an invaluable asset to the city, and whereas the City of Rapid City finds that off-premise signs adversely affect the scenic beauty of the city, and whereas the City of Rapid City finds that off-premise signs have proliferated within the city limits and has expanded to new areas, and whereas the City of Rapid City finds that off-premise signs, and specifically billboards, are lawful in the state of South Dakota, and whereas the City of Rapid City finds that off-premise signs tend to annoy persons frequenting public streets, regulation of off-premise signs is essential to effective traffic regulation, finds that the height of off-premise signs adversely affects the scenic beauty of the city, finds that the height of off-premise signs affects the health, welfare, and safety of the users of both public streets, that the size of off-premise signs adversely affects scenic beauty, etc. It went on to then detail specific ordinances related to that, and that's what we're here to talk about today. So it goes against the spirit of the ordinance that we've had on the books. It goes against the initiative, okay? Those of you on the dais are representatives of Rapid City. The citizens spoke very loud and clear in 2011 that we want fewer, not more billboards, fewer, not more digital billboards in particular, for several reasons, for scenic beauty, also for safety issues. This proposed settlement goes contrary to the public will, and we look to you as our elected representatives to represent us in this way by voting against this proposal. I have here in my hand a 200-page document that cost the city $200,000 to produce. It's called the City's Comprehensive Plan. There are people a lot smarter than I that came up with this document. There's a section in here that specifically details, this was completed in 2014, regarding gateways and entrance corridors, and signage is referenced in here. And the idea behind the comprehensive plan, and it specifies Interstate 90 at North Elkville Road, Interstate 90 at North Deadwood Avenue, Interstate 90 at Interstate I-190. Signage is mentioned in here, and the premise behind the comprehensive plan is that we have a plan A, and that we stick to it. Why do we have ordinances? Why do we have plans? Why do we have elected officials if we're not going to stick to these plans? Each of you took an oath of office to represent and defend the Constitution and to represent us as the citizens. And the mayor had written the council back in November of last year as they were reevaluating their mission and vision statement and values. And I found that on the website this morning, and the mayor's letter, quote, "The city council is the City of Rapid City," you are, and you are our representatives. We have no other voice. We also know that the mayor was annoyed with the dismal turnout in the recent election. Okay, we all are, for those of us that care for our fine city. With this proposed settlement, essentially what you're saying is, if you're a concerned citizen to the point that you go out and get enough signatures to get an issue on the ballot, you succeed in that by over 2 out of 3 voters, only to have it all turned around, as this proposal suggests, several years later, might explain why we have some voter apathy in this town. Just saying. The vision statement of the mayor and city council talks about enjoying the quality of life. I'm not sure more billboards is going to generate more quality of life. The mission is to serve Rapid City with integrity and excellence. Does appeasing the billboard industry and capitulating to their demands, as is the case here, represent integrity and excellence? That's the challenge I put before you. The values in this statement: a safe and healthy, inclusive and skilled community. How safe is it to have 650 square foot billboards along our interstate with people rolling down the road at 75 miles an hour? Also in your statement, it's to be responsive, accessible, and effective governance. How responsible are you being to the citizens that entrusted you to vote for our interest by proposing going along with this settlement offer? Webster's defines appeasement as the policy of granting concessions to potential enemies to maintain peace. Capitulates defined as to cease resisting, to acquiesce. We all understand, we'd like to see the end of this, but I can tell you this settlement's not going to bring the end to anything. If you think that by throwing this out and agreeing to this is going to be the end of it, I'm sad that you're sorely mistaken. I've done enough research on this around the country. This will just be one more chess move in the match, in the game. Do we really want to demonstrate and just throw in the towel, as I see in principle what you're suggesting here? The proposed settlement will not end the battle. It won't bring peace, but it will invite more litigation from the outdoor advertising industry. History proves this out in other areas of the country. We can and we must do better than this on behalf of the citizens of Rapid City. The world is watching what we do here and now. Do the right thing. Reconsider what you are approving for future generations who wish to call Rapid City and the beautiful Black Hills their home. Vote no on this proposal. Thank you.
Thank you, Mr. Ainsley. Now on to Deborah Jensen.
I don't know why the quote, "the war to end all wars," comes to mind, but sometimes it does. Good afternoon, members of the Rapid City Common Council. My name is Deborah Jensen. I'm the Secretary of Scenic Rapid City, co-owner, along with my husband, of a small business in Rapid City, and I happen to be a fourth-generation South Dakotan. Like Andy and like all of you, I love Rapid City, and I love the Black Hills, and especially, of course, South Dakota. As council members and leaders of our community, I know that you want to do what is in the best interest of the citizens of Rapid City, as well as be a responsible, good steward to the taxpayers' money. Time and time again over the years, Rapid City leaders and citizens have all wrestled with the billboard issue. Some of the first attempts to control and reduce the number of billboards were made by previous city councils decades ago, some of you may remember, as I do, with the introduction of sign credits. There have been moratoriums. There have been ad hoc task forces, a few of those. There have been bills in the state legislature, and of course, citizen-led initiatives of which I have been involved in a part of. Nearly every attempt to regulate off-premise billboards has ended up in court, or court action has at least been threatened. Because of concerns of costly, protracted litigation, previous councils often settle, despite the wishes of the public and certainly the best interests of the citizens. But lawsuits are a reality, and they are a very unfortunate consequence of citizens, taxpayers, civic and city leaders all trying to just do the right thing, which is trying to improve the lives in our community. History shows that settlements do not stop lawsuits and rarely resolve long-standing issues. In this particular case, federal highway laws state that a 30-foot maximum height for billboards is not allowed. A consequence could be a federal highway funding penalty. It is certainly worth rechecking that interpretation, as we have received an interpretation from a few different sources that say that is an issue. This agreement also adds to the 400-plus billboard faces that are already in our city limits. It may open the door for yet another lawsuit to approve other large billboards within our city limits, or perhaps some variances in the spacing. Just a few years ago, as Andy also mentioned, a citywide election with an election turnout that was much higher than the one that we had just last week, 66% of Rapid City voters said very loud and clear the community wants reasonable regulation of this very flourishing industry to help preserve, to protect, and to improve the lives of all citizens. It's why Rapid City, Scenic Rapid City, and many other grassroots organizations form, and they have been forming in the last few years. It's all to help our community be safer, cleaner, more livable, and of course, more enjoyable. And so like Andy, I join him and others in asking you to not agree to this proposed settlement as it is written. Thank you.
Thank you. And the next speaker is Mike Kwasny.
Thank you. My name is Mike Kwasny. I'm with Scenic Rapid City. I'm the treasurer. I also happen to be on the Planning Commission, so my book has a few more pages marked and so forth. I had a prepared list of reasons to not accept this compromise, comparing the comprehensive plan to the compromise. But I've set that aside. Quoting statements in our comprehensive plan, comparing the compromise and the city plan, showing this is not a good fit. Comparing these is yours to do as elected officials, so I will not use my time to do this. As I sit on the Planning and Zoning Commission, I try to use the comprehensive plan to help guide me on many issues, including signage and beautification of our community. As I see it, we all have a responsibility to protect our community. A community that sits in the middle of what I see as one of the best places to live. An area filled with so much natural beauty. The comprehensive plan talks in many places about signage, bringing it lower, reducing size to allow us to focus on this natural beauty. The plan makes reference to the entry points to our great city and what we need to enhance this community. I would ask that all consider what this compromise does to negate what we are trying to accomplish with the comprehensive plan. I would also ask, why can't we expect the industry to join us and not fight against us on every turn? We expect all citizens to conform as we change. We expect them to cut lawns, remove snow, put sidewalks in, all in an effort to move our community forward to look its best. This is at a cost to them, but we still expect it to happen, or we go in and change it. We do it ourselves and we charge them. The city does. Why can't we expect the sign industry to change with the community's plans? Keep signs smaller, minimize digital signs. We need to decide what we want. Do we believe in our comprehensive plan? And are we ready to show that commitment? I would like this opportunity to publicly ask the sign industry to participate in the comprehensive plan, to reduce signs that are, especially signs that can no longer be filled, to not light up our night skies with any more digital signs, to protect our views wherever possible. Please join us in this comprehensive plan. I would like to leave you with a visual. I need you to go to one of our entrances, to Sign Row. Imagine all those signs on I-190 or I-90 turning digital. Can you picture that? You might say that won't happen, but we are going there with this compromise. We are taking one more step towards exactly that. I thank you for your time today, and I thank you for your consideration on this matter. It's very important as we move forward. Commit to the plan, please.
Thank you. Still on item 12, Mr. Mike Sabers.
Thank you, Mr. Roberts. My name is Mike Sabers, and I represent Epic Outdoor Advertising here in town. Two issues I'd like to address just very briefly. First of all, there are no new sign locations. I've never been told I'm not loud enough.
We can hear you now. You were kind of out of the
Realm of the
realm,
microphone?
yes.
All right. There are no new sign locations in this settlement agreement. That is the first issue. And the second issue that was inferred by Ms. Jensen but not directly addressed was a reference to federal highway funds. When you go to law school, you learn a lot about these books. These books contain the laws of the state of South Dakota. And the statute that she was referring to, and I'll read it, it talks about the maximum sign face, how big a sign face can be, South Dakota law. And it talks about it cannot exceed 30 feet in height and length. That's to include the border and trim. But the statute explicitly says, but not supports or apron. So the statute specifically addresses it, because if you take, there really is no interpretation. The state of South Dakota has always said that it's the sign face, excluding the support and the apron, and the support is the pole. This is a compromise settlement agreement. I have worked with Mr. Landine and the city for quite some time. Both parties have compromised. My client has compromised significantly in reaching this compromise settlement agreement to end long litigation before it becomes more expensive. So my client would ask that this group approve and send to the council for the vote the settlement agreement that has been it's been worked on for almost a year now, specifically this settlement agreement. We would ask that you send it to the council for a vote. Thank you very much, and I would answer any questions, but I'll leave that up to you.
Thank you. And that's the end of the speaker session, so I will close it. We'll get on to item 10, second reading and recommendation of ordinance number 6180, an ordinance to update the Life Safety Loan Program funding and process by amending Chapter 3.28 of the Rapid City Municipal Code. Move to approve. I have a motion to approve and a second. All in favor? Aye. All opposed? Motion passes. Item 11, authorize mayor and finance officer to sign settlement agreement between City of Rapid City and President's Plaza LLC. Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I'd like to make a motion to send this to council without recommendation. Since it is a settlement agreement, I believe the discussion would be more pertinent Monday night when all members of the city council are present.
Second.
Thank you very much. We have a motion on the floor to send to the council without recommendation and a second. All in favor? Aye. All opposed? Motion passes. Item number 12, authorize mayor and finance officer to sign settlement agreement between the City of Rapid City and Epic Outdoor Advertising. And we have our city attorney first in the queue, Mr. Landine.
Thank you, Mr. Chairman. I just wanted to address something that one of the speakers said. I saw an email from Ms. Jensen earlier regarding that the issue with the federal highway funds and the interpretation of the 30-foot. I would just reiterate what Mr. Saber said. I've reviewed the statute, and I don't believe there's any question that it's talking about the sign face. But based on Ms. Jensen's assertion that she had talked to people in Pierre who expressed a different opinion, I took it upon myself to call Carla Engel, who's the chief legal counsel for the South Dakota Department of Transportation this morning. And in my conversation with her, we discussed the statute in question. She agrees that Mr. Saber's and my interpretation is the correct interpretation. It is the sign face. The settlement will not violate state law or the Federal Highway Beautification Act. It will not affect federal funding. I would also point out that Sioux Falls has already adopted that. And in fact, Ms. Engel said if I could find out who Ms. Jensen spoke to, she would be interested in that information because she wants to make sure that their staff is giving out the correct information.
Thank you, Mr. Landine. Alderwoman Modrick, you have the floor.
Thank you, Mr. Chair. I'll just tag on to you if I can. I've got a question on that because what you're saying is that in state statute, we abide by the law. Did you happen to contact the Federal Highway?
No, but the state of South Dakota is responsible for administration of the Federal Highway Beautification Act in South Dakota. They are the responsible party to administer that.
And another question I have on that, Mr. Landine, is where are there 672 feet digital billboards along the interstate?
I can't answer that.
So when you talk to them, did you ask them if this has been brought before them before to put this size of a billboard, fully digital, potentially illegal video motion in the city of Rapid City city limits?
The state of South Dakota does not prohibit digital and does not regulate whether it's on the interstate or not. And in fact, I'm sure as you're aware, when the initiated ordinances went through, there was actually a push by the state legislature to prohibit cities from banning digital billboards. And that passed pretty handily through the legislature and was only not implemented because the governor vetoed it. And it was very close. Something to understand politically let's be clear, this settlement, there's nothing involving digital, nothing related to digital signage is changing through this settlement. However, the reality is, and I'm sure Ms. Alderman Modrick will point out, is that this is the intent of EPIC is to convert these signs to digital along the interstate. And I am not aware of digital along the interstate. So to that point, it certainly is going to change the digital along the interstate. However, the actual ordinance changes you're agreeing to do not change anything to do with video. That's already allowed. It's just at 250 square feet. It's just nobody's converted to that yet because I think the sign companies would tell you that that's too small on the interstate at that speed to justify the bigger size.
Mr. Levine, I want to ask you then, if it was already previously 90 feet on the interstate, then why would 250 feet be too small?
What do you mean 90 feet?
Well, I think it's a small billboard that's there now. So it was effective at some point, but now enlarging it somehow is magically going to make that more effective?
I think that the investment in digital, that they're going to want to make sure it's read. I mean, that is the way sign codes are going. I mean, look, that's part of it. And I would take a little issue with there is a new location, although it's actually in the process of being applied for now. It's a legal location, which is the one along Dias Avenue. But when they look at the investment, traditionally now sign codes are going to the size of the sign is dependent on the speed at which the roadway in which it's meant to be viewed. So the higher the speed, the larger the size of the sign. So I'm just telling you what the sign code, I'm not an expert in distances and sizes, but what the people from both EPIC and Lamar would say is that the higher the speed on the roadway, the larger the size, which is part of how we got to this settlement and agreeing to the larger size just along the interstate, which has the higher speed.
So just to complement your statement, We have reduced our speed to 65 along this stretch that we're talking about. So we have reduced, which should also allow our current sign code to not be jeopardized by change or by a change by one company from within an industry where it has several involved, umbrellaed under that industry. You mentioned the motion. However, the motion is prohibited in our sign code. So it's full motion images and graphics or video are prohibited. It must be a static sign, so we need to endorse and enforce that. And we know that we currently have digital from Epic that are not abiding and haven't been for years and have been running full motion video, which is basically your television screens, which was placed by councils previous to us to make sure that this was a good regulated sign code. That way we're following what the community has been requesting among city councils long before us. We're probably talking about 2 decades and numerous changes. The comprehensive plan, that is important to all of us. We've reviewed it, we've read it, we've tagged it. One of the pieces that's in here, responsive, accessible, and effective governance. It says, while we value effective local governance and city organizations that is fiscally responsible and accessible and responsive to residents and businesses, our community will seek effective local governance and promote community-based collaboration with opportunities for involving citizens in all city decision-making processes. This is a value statement. It's valued by us as a council, those that fill committee seats, and as well as the citizens of Rapid City in this comprehensive plan. The same statements that we have in making sure we're working with our reasonable regulations from within our code, which has been reviewed and counter-reviewed and adjusted numerous times to make sure that it's in balance with the citizens, the community, and the industry. And about every single, I have yet to find where there hasn't been a very expensive study that hasn't been done, where we're not talking about incorporating these values and bringing the industry and the community together. And with those countless hours that the citizens and the councils have done in previous times, those count in this sign code. This is not the time to change a sign code for one entity, but to actually use our enforcement of a code that's been written and has been sustainable now for many years. And it is reasonable regulations that are in our sign code. It's gone through the process. The other part that I want to acknowledge as well is that the citizens are insured by the initiatives of which they brought forward. And the City of Rapid City has, we have a responsibility to endorse and follow through with that. Although it was a 2011 initiative, it's historic, it's valuable, and it will never go away. It's something that does stand before us, and we need to always remember what they wish for. So if we're actually doing the rights of the citizens, then we should proceed with courts and judgments, because we have the citizens that would like to see that we use those and maintain those regulations. 672 square feet of digital billboard could be detrimental to our community. There was one statement made that was that the interstate is not part of our community. However, right here on the council in Ward 4s and 5s, we go across that interstate. It is part of our community. And we don't have control if it's going to go on Box Elder or in Blackhawk or in Piedmont and all the encroachment that's coming with 500 distant signage. But as stated, if we begin the process of digital, and we do become the first digital sign on the interstate, of course, this isn't going to hold for just one company. We will need to be fair to all companies. So we need to be prepared for what we're changing in this code. And frankly, this code in any kind of change or format needs to be evaluated by a citizens group, a committee, and the industry before we just start picking out one item at a time and saying, well, we're going to change this for one industry, one member, just because we've been provided with a threat to the citizens of Rapid City. So it is, of my opinion, that this is not the way that we need to go forward with this, but perhaps protect our community with safety and the rights of those that would not want to see enlarged billboards or more billboards, whether it be on the interstate or in other protected areas of our community. And with that, Mr. Chair, I'll end for the moment.
Alderwoman Scott, you have the floor.
Thank you. I'd like to make a motion to send this to council without recommendation since it is a settlement agreement. Thank you.
We have a motion and a second on the floor. All in favor? Aye. All opposed? One no, and the rest yeses. I believe, yes.
Motion to adjourn?
We have a motion to adjourn and a second. All in favor? Aye. We are adjourned. Thank you.